Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today we are talking about a partnership with a capital P, and we're talking about a piece of property with, I suppose, a lowercase p that is owned by this partnership. A little bit of the background. Back in 1991, this partnership was established, and the partners were a deceased person who we'll call Mum, another natural person who we might call one of the kids, and a couple of relevant companies. Now, time passes, and in 2022, sadly, Mum passes away, but the property remains one of the assets of this partnership. Probate of Mum's will is granted to the relevant executors, and so they are left to administer Mum's estate. But after some time passes, there is conduct which one of the parties refers to, or might loosely be described as foot dragging on the part of the executors, and the process of realising the partnership itself and the real estate slows down. What we have today is the plaintiffs coming to court and seeking a few orders. Those orders are an order appointing a trustee to sell the property, a trustee for sale, pursuant to section 66G of the Conveyancing Act here in New South Wales, and seeking a winding up of the partnership itself. Right, two separate things. Are we going to get an independent trustee appointed to sell the property, bring in the money, and distribute the proceeds? Yes or no? That'll be the question the plaintiffs want to put to the court. And are we going to wind up the partnership, bring it to an end now that Mum has died? There is a course of correspondence over years, and by the time we get to the final hearing, interestingly, both the plaintiffs, the people who have come to court seeking these orders, and the defendants, the people who were originally resisting the orders, have come to a position of agreement. And all parties say, look, tick, yes, let's get some 66G trustees in. That seems an appropriate thing to do, get someone in independent to sort this stuff out. And yes, let's wind up the partnership and bring the arrangement to a close now that Mum has passed away. The one matter left not agreed between the relevant parties is legal costs. Right? Traditionally, when we think of one of these section 66G applications, you have two co-owners of a property who disagree, but they appoint someone independent. The independent person sells the property, and the legal costs of these parties who are disagreeing get paid out of those sale proceeds. And that's what we might call the prima facie position, or the first position that the parties adopt, unless there has been some unreasonable conduct from one or the other of these parties. Similarly, in relation to the dissolution of a partnership, the legal costs involved with coming to court are sometimes thought of an incident of the partnership itself, and so are thought of as a cost of the partnership, and so are paid from the residue that arises after the winding up of a partnership, if that makes sense. So the kind of first position, what we lawyers think of as the prima facie position, is legal costs from 66G proceedings are paid from sale, both plaintiff and defendant, and legal costs from winding up of partnership proceedings are paid from the residue of that winding up, both plaintiffs and defendants, unless there has been some unreasonable conduct. Now, what the plaintiffs say is, look, we all agree on 66G, we all agree on dissolving the partnership, but we say we should get our costs from the residue of these things, and the defendants should not. And the reason we say that is we say they acted unreasonably. What the defendants say is they say, nah, it should be the normal position. Everyone should get their costs out of the residue. And so the court is left to consider this position. Now, what the court does is look through some evidence before the court that evidences, a few years of what might be thought of as like foot dragging behaviour, as the plaintiffs might characterise it, and says, look, I can see there's some evidence of some back and forth, of some negotiation that until the hearing itself didn't end up with a path to the sale of the property. But the court says that we don't have enough material to conduct a mini trial, essentially, in order to find that one party's been unreasonable and one hasn't. That means we don't have enough in front of us to say one party was unreasonable, and that means that it's going to be the normal costs position. And so what the court orders is, yep, get those 66G trustees in, and get someone independent to sell the property, yep, let us wind up the partnership and deal with the residue, and yep, both parties are going to have their legal costs paid from the residue of those relevant funds that are going to arise. I hope that quick discussion assisted you, and I look forward to chatting again soon over another coffee and in respect of another case note.